Everyone hear me?
Yep.
Sure. All right, coming through loud and clear. All right, how's everyone doing? Everybody have a good week?
Yes.
Great. As you can see, I've got some updated data on the board here. There was actually 2 polls that came out this week, one from The Economist and one from Reuters, and there's a pretty significant disparity. 15% from The Economist approval rating and 25% approval rating for congressional job approval for Reuters. This is actually very high. So according to this, one out of 4 of you is going to approve of Congress. That's remarkably high. Okay, so last time we discussed the doctrine of judicial review. We discussed the 1801 case of Marbury versus Madison and talked about judicial review. The notion that the federal courts are the final arbiters of the Constitution, specifically the Supreme Court. The Supreme Court has the final word on what the Constitution means. As Justice Marshall said in the opinion, it is emphatically the province and duty of the judicial department to say what the law is. So we know now that we cannot simply just ask the Constitution as an inanimate document to interpret itself. Nor can we read the entrails of sheep offered up to it to ascertain whether or not we have offended the constitutional gods. Someone must be charged with interpreting the Constitution, saying what the Constitution means and doesn't mean, and why Marbury versus Madison is so important is that decision tells us in clear terms it's the Supreme Court. That interpreter, that arbiter of the Constitution, the final expositor of the Constitution is the United States Supreme Court. We also talked about different schools of thought as it pertains to interpreting the Constitution. And so everyone agrees now that the Supreme Court has the final say on what it means, but people differ on how the Supreme Court should go about interpreting. So we talked about the difference between people who think that the text of the Constitution, the meaning is static, or it's fixed for what it meant at the time of the framing, and people who tend to think that it's as they would say, a living document, that the meaning of the words, the meaning of the phrases is dynamic. It can change over time. It's flexible to fit our modern milieu. And then next we talked about the notion of federalism, which is the word for the relationship between the federal governments and the states, and we saw that just like judicial review, it's a reality that everyone accepts as being real, but people have, since the foundation of the Republic, disagreed pretty vehemently on exactly what it means. And so I think we discussed 3 different theories of federalism, and I think you can kind of chart these as we put out on a spectrum more or less. We talked about compact federalism, the notion that the federal government is actually constitutive of the states. That ultimate sovereignty lies with the states, and the states have chartered the federal government, and that it's a compact or a league, a confederacy of independent sovereign republics that have an administering federal government. And then we talked about dual federalism, this notion that the people in aggregate, the accumulation of American people together, of all the states, have granted power to both their respective states and to the federal governments. And so both layers are dual sovereigns over the American people. And then lastly, I think we discussed the notion of cooperative federalism, something that became very popular at the advent of the New Deal in the 1930s and 40s with the expansive administrative state, expansive regulatory bureaucracy, and the notion that the states and the federal governments are kind of working in unison, doing the same thing. It's hard to see where one ends and the other begins, more or less. And then we finally talked about the different categories of congressional powers, namely enumerated powers. Those are powers that are expressly granted to Congress in the Constitution. Inherent powers, powers that Congress has just by virtue of being a national government. For instance, the powers to acquire territory and to defend borders, to patrol coastline, things like that. They just come with the territory of being a national government. And then what we're going to discuss today is the third category, implied powers. So what are implied powers? Anybody want to take a stab and tell me a good description of what Congress's implied powers are? If I were to try to find, where would I go in the Constitution to try to find the basis for implied powers? Any questions so far, by the way? Last paragraph of Section 8. That's on what, page 3 or page 4? Page 4. So this whole section begins with the words Congress. The Congress shall have power to, and the last clause of this section on page 4, it's the last underlined paragraph. Power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That is our subject of discussion today, which is known as the elastic clause, also sometimes called the necessary and proper clause. And this is the textual basis for Congress's implied powers. So there are certain things that Congress has the power to do that are not explicitly set forth, that are not stated expressly in the text of the Constitution, yet nonetheless they are, if you will, a means to an end to fulfilling those enumerated powers. In the first case we're going to discuss about this, the most important case, the foundational case for understanding exactly how we understand implied powers and necessary and proper clause, is McCulloch versus Maryland. It's an 1819 case. Also, Chief Justice John Marshall authored this one as well. Everyone have a chance to read the summary that I provided in the syllabus of McCulloch versus Maryland. Somebody tell me what's this case about? Taxes on what?
The United States.
Banks, any particular bank?
Of the United States.
Bank of the United States. Okay. First of all, is this a case about what Congress can do, what Congress can and can't do, or is it a case about what the state governments can and can't do?
States.
It was trying to decide one of those questions, wasn't it?
Yeah, but is it? I propose it's both. Yeah, it's both. It's both what the state. It's almost talking about this in a zero-sum game. So this is a case about the Bank of the United States. So what Bank of the United States is it? It's not the first Bank of the United States. It's the what? The second Bank of the United States. So that implies, no pun intended, a first Bank of the United States. So the first Bank of the United States was the idea of one person, Alexander Hamilton. Alexander Hamilton he was the first Secretary of the Treasury in the Washington administration, and he had a very robust vision for the economic character of the new American Republic. He knew that because all throughout the colonial period, Great Britain had kept America capital hungry, had starved America of capital and concentrations of wealth, because that's how the mercantilist system of economics, that colonial economic system, functioned. Is Parliament did not want too much capital and wealth accumulated in the colonies, because then it was a rival to the European market. The mercantilist economic purpose of the North American colonies was just to extract wealth and bring it where it would be profitable in the European market. They wanted to keep America capital poor. Does it make sense? So Alexander Hamilton wants to, he understands if we're going to be a real nation and be recognized by other European nations, then we need to have a robust American economy that's bent on promoting and fostering commerce and industry and manufacturing and trade, stocks and bonds, Because otherwise, we're going to continue to be a simpleton, agrarian, nothing but farmers, and thereby just an appendage, an economic appendage of Europe. And then ostensibly, still, even though we're independent on paper, we're still functionally dependent upon Great Britain. Hamilton did not want that. And so he proposed a system of economic policies, which included the federal government assuming the Revolutionary War debts of all the states, and several other measures which would boost the national credit, the public credit of the federal government, and also the biggest thing that he wanted to propose was a national bank. Was a bank that was a joint public and private enterprise where the federal government would own 25% of the shares and would appoint the directors, and then would allow for private investment so that American merchants, American manufacturing entrepreneurs, American industrialists and capitalists could have access to capital, could have access to credit, to borrow, to begin to get the American economy rolling, where it would not just be an appendage to the European economy. There were people who really, really, really did not like this idea. Who would have been one of them? Someone who strongly objected to this, Thomas Jefferson, because Thomas Jefferson and his and people who were like-minded had a very different vision for the new republic. They said, yes, exactly. We do not want to be like the European nations. What you are proposing, Mr. Hamilton, is to, even though we're technically a republic, we don't have kings and princes, etc. You are making us into the same kind of industrial, speculative, money-grubbing culture that it's bent on what they saw as false wealth. You know, the more Republican, purist, ideological Mad Dog Republicans like Jefferson and other people like him, they thought they had a moral dilemma with stocks and bonds and speculation and banks. All of it was people who did not have real wealth. Their standard of real wealth was property ownership, land, because their model of republicanism was the ancient Roman Republic, where virtuous citizens who farmed and owned land, and who governed each other and were governed by each other and had virtue to govern one another's affairs. They saw the Hamilton's economic system as an affront to civic virtue that would sustain their vision of the republic. And so, just as Hamilton was the Secretary of the Treasury, Thomas Jefferson was the Secretary of State. And the Attorney General, Edmund Randolph, I think we mentioned him last time, he was also a mad dog, ideological Republican purist. And also James Madison as well. They were all in Washington's cabinet, or very close in Washington's cabinet, and they had urged Washington, do not sign this bill, Mr. President. This is not constitutional. First of all, it's bad policy. This is going to take our republic in a different direction than what we want it to be. It's going to Europeanize us, and we don't want to be like Europe. We don't want to be like Britain. And as I think we mentioned last time, Washington tended to lean more federalist. His sympathies were more toward the Hamiltonian ideas of things. And so I think we mentioned last time, Washington asked both the gentlemen, Jefferson and Hamilton, to submit memoranda to him, and he would assess the merits as to whether or not this bank was constitutional. And Jefferson's primary argument as to the unconstitutionality of the bank was, hey, the Constitution is absolutely silent on the matter of banks. It just doesn't say, the word bank is not there. Congress has no grant of authority to be making banks. Alexander Hamilton says, you're right, but there's this necessary and proper clause that we just read. And the bank is a conducive and useful and expedient means to the end of all of these different enumerated powers. For instance, Congress has to build and maintain a navy. Congress has to deliver the mail. Congress has to raise armies. How is Congress going to do this if they don't have a robust system of finance where they can draw funds from? You're going to keep the federal government starved where it cannot actually do anything, Mr. Jefferson. So Hamilton won out, and Washington signed it. But as we also learned last time, what happened in 1800 in politics in America? Year 1800.
Jackson got elected and eliminated the bank.
Well, that would have been in 1836. That's later. We're going to get there. But in 1800, so you had Washington as president. Then you had for 2 terms, and you had John Adams, who was a even more staunch Federalist for a term. And then in 1800, Thomas Jefferson was elected. Not only, as we mentioned last time, is apropos to our discussion in Arbery, but not only did the Republicans take the White House, they took both houses of Congress. And so after Jefferson, Jimbo Madison himself became president, and he was also a Republican. And so the bank that was chartered by Congress, signed by the president in 1791, Hamilton's first Bank of the United States, had a 20-year charter. 1791, it expires in 1811. By 1811, Congress is filled with Republicans, and they are not going to renew this charter. They don't want, because the bank is not consistent with their view of the republic. So they let it lapse. They let the charter lapse, and it just falls away. So that's 1811. Well, along comes 1812. Can anybody think of a significant event that happened in 1812? Wow. So, wow. We're in another war with Great Britain. Oh gosh, look what we don't have. Money. Wonder why? Because we let the bank collapse. Here we were getting all this interest from all these. I mean, the first Bank of the United States was actually the largest corporation chartered in the world at that time because of all the capital. So American merchants, American business and commercial interests were able to get access to all this money, all this capital, all this credit, and the economy was beginning to boom. But that's not what, the Republicans did not, it wasn't that they didn't like money. They weren't Marxist or anything like that, but they did not, they had a vision of prosperity and virtue that was just, which they saw Hamilton's idea of commercial capitalism as repugnant to. Does that kind of make sense? And so after the War of 1812, even many of these Republicans start to think, maybe that bank was a good idea. Maybe we were thinking too quickly there. And so there were Republicans that styled themselves as national Republicans. And they included people like Kentucky's own Henry Clay, Daniel Webster, John C. Calhoun, and even James Madison came over to them. When he was president in 1816, Congress had passed a bill for a second Bank of the United States. And even Madison, who had been such a staunch opponent of Hamilton's first Bank of the United States, Madison signs it into law because he says, okay, I've sure learned my lesson from fighting 2 wars with the British. We need a bank. We need something that will promote the kind of commerce that will make us a strong enough nation where we're not just an appendage to Europe. And so, however, so they chartered the second Bank of the United States in 1816 and also gave it a 20-year charter. So this is where you brought up Andrew Jackson earlier. 1816, 20-year charter ends in 1836, which is when Jackson becomes president. And that's when he has Roger Taney go at it with Nicholas Biddle, and he demolishes the second bank. But it's still standing right now. However, even when the bank was first passed, it did not take long for this second bank to wear out its welcome with the American people, especially among people who were the more staunch Jeffersonian Republicans. So you have to understand that when the first Bank of the United States had been chartered back in 1791, there were only three banks in the entire country. All of America, 3 banks. But by the time the second Bank of the United States was chartered in 1816, there were over 250 local and state banks in America. And they did not really like this notion of competing with the federal bank that had much, much more capital on hand. And so the directors and the stockholders of all these state banks began to pressure the state legislatures to oppose the bank. And it turns out that the state legislatures didn't really need much pressing because the Second Bank of the United States had made all of these loans to the states, and when these states began to default on the loans, the Second Bank of the United States called them in. And the states didn't like this because there was something. The bank had actually helped trigger what arguably was the greatest financial catastrophe in American history, even perhaps more serious than the Great Depression. So after the War of 1812 ended, there was a brief post-war economic boom in America, and it resulting from this surge of American exports of agricultural products and manufactured goods to Europe, because Europe was still in the throes of the Napoleonic Wars. And so, however, when these wars ended, this surge in demand that had caused so many people in America to seek more credit and buy more land in the West and cultivate and invest so much more money into manufacturing and farming, all of this had created this big speculative bubble in America. Well, these wars end. Europe gets back after a couple of years, is able to get back on its feet, and demand the bottom drops out of demand for American goods. So there is this major economic bubble. Then there's a market change. Everything collapses. Everybody loses their jobs and farms. Gosh, sound familiar? Man, it sounds like October of 1929. It sounds like June of 2008. I mean, it's the same thing happens over and over again. So you had the banking, a national banking and finance system that hyperextends credit and then contracts credit rapidly. That's what happened in 1819. This caused people to absolutely loathe the Bank of the United States. I cannot emphasize. There's not an institution in America I can think of that was probably more. I mean, if you put like the NRA and Planned Parenthood together, they wouldn't be as loathed as the Second Bank of the United States was in 1818 and 1819. Because there was just so much corruption in the bank. All of the different branches, all the newspapers were bringing all this corruption to the bank. And the bank was the one that had extended all this credit, that led people to leave. There's money just going everywhere. And then they called in all the loans, tightened the credit up, and everything collapsed. A third of the American people went broke. It was bad. People hated the bank. And so the states reacted to this. Now, something interesting, it created in America this kind of atmosphere of debtors versus creditors. So you had all these creditors and all these other banks, they were now at odds with all this big mass of credit, all these big mass of broke people. So I think we saw what happened in 2008 when there's a big financial collapse, there's a political shift as well. And so something interesting happened in Kentucky. There was from 1818 to the end of the 1820s, in Kentucky there were actually two Supreme Courts for a while, two state Supreme Courts, because there was a pro-debt relief party that took over the state government, and they tried to cancel all the mortgages, cancel all the loans by statute, and the Supreme Court at the time said, no, you can't do that. That's against the law. So what did the state legislature do? They said, let's just make our own Supreme Court and appoint people who will just rule the way we want to. So for about 8 years in Kentucky, there were two Supreme Courts. And I think it was like 1828 when they finally said, okay, this new court needs to go away. We're the real court. So if you want to research that, it's super interesting. So in other states, you saw another thing Kentucky did in this time was they put a $50,000 per year tax on each of the branches, the Louisville and Lexington branches of the Bank of the United States. The states like Indiana and Illinois, they just wrote provisions in their constitution saying no bank that's chartered outside of this state can ever do business in Indiana or Illinois. So the states were trying to put prohibitive measures to obstruct the operations of the Federal Bank of the United States in their boundaries. Now, Maryland had done something, compared to these other states, had done something kind of a lot more mild. What did Maryland do? What was Maryland's measure that's described in the summary there? What was Maryland's measure they had on the bank? Was it a direct tax? Was it like what Kentucky and Ohio did with hey, we're just going to, if you have to do business in Kentucky, you have to pay this huge What's that?
First I have to understand something.
Yes.
Did the federal bank
Mhm.
have branches in the various states?
Yes.
Is that what they tried to do?
Yes, in 18, yeah, there were,
So they
there,
had a federal bank
yes.
versus local people forming a bank.
Yeah, and there were local banks.
So they had
Mhm.
both in
Yes.
different states.
But yes, that's right. But there were different think of like the modern version of this is like the Federal Reserve. Okay, so like the Federal Reserve, established in 1917, there's branches in different cities. I think there's 12 branches, I think. But those cities are within states, right? So this is much before the Federal Reserve and somewhat different. But there were branches that, yes, sir.
Go ahead.
There were branches of the federal bank, second bank of the United States, in the states, like field branches. But the state banks, of course, in the context of the economic collapse, they were unpopular. But also the banks that were there, you have to understand, the federal, even before the financial collapse, the state banks don't like to want to have to compete with the federal bank because the capitalization of the federal bank was just beyond anything that the state banks could ever achieve. So if you're like John Jacob Astor or someone like in the early republic, this multi-billionaire to today, you're going to do business. Well, you're not going to invest in put your money in state banks. You're tracking the bigwigs to the federal bank. Did I answer your question?
Well, that was, I wasn't
Yeah.
quite understanding.
Yeah.
To me, I think of the federal bank as being in Washington, and I
Yeah.
don't really understand that they also had branches.
Yeah, there were branches in each state. Now, like I said, Indiana and Illinois prohibited in their constitution no banks that are only banks that are chartered by the Illinois legislature or the Indiana legislature can do business in these states. Yes, sir.
I said Maryland said that you could only print money with their paper.
Yes, Maryland. Yeah, Maryland said, okay, you want to come bank in the United States, if you want to do business in Maryland, go right ahead. But if you're going to issue banknotes, they have to be issued on stamped paper that you buy from us. The banknotes you issue have to comply with us, right? So it's not a direct tax, I guess, like what's going on in Kentucky and Ohio, but it's less mild, but it's still effectually a tax, okay? So who at this time is the cashier? Now we think of a cashier as like a lower position, but the cashier was like the president of the director of each branch. So who is the cashier of the Maryland branch?
McCulloch.
James McCulloch. And so what does he do with respect to this tax?
Refused.
He refused it. He said, I'm not doing that. Now, before we go making a hero out of Mr. McCulloch, thinking he's this, guy who's standing up to the bad state of Maryland for their own constitutional act, let me just be honest. James McCulloch was a crook. He was a crook. In fact, after this, when all this was going on, he was being investigated for embezzlement because he himself, as the cashier, him and his business partners had embezzled something like $3 million in 1818 money, and then lost it all. Like they took out loans for themselves and then lost it all on bad investments. He's a crook, okay? But let's set aside the idea that he's a crook right now and act like he's maybe this guy who, yes, sir.
Is this a time when there was only one money in the United States?
Well, oh gosh, that's complicated because how it worked was there wasn't anything that there was our notion of paper money that we have today was not quite how paper money worked then. True money was specie, it was gold and silver coin. That's what banks had in their vault, and they issued banknotes. So a banknote is you could take that to a bank. From which it was issued, and you say, I want this, and I want to get the amount in gold and silver that this banknote allows me to get. Well, what caused this collapse is the banks had issued so much credit and had given out all these banknotes, and then there's a tightening of credit. People don't trust the banks anymore. They go to the bank to get their money out, and the banks are out of gold. They don't have any actual cash. They don't have any actual real money. This is what happened in 1929, more or less. So I'm not an expert on exactly how I would describe the difference, and it's not quite. It was somewhat different, far cry from how we understand the money today. Of course, we have, I guess, what many might call
You
fiat
got
currency.
a note from a Kentucky bank,
Mhm.
and you went to New York. The New York bank didn't necessarily give you anything for that piece of paper, because that was issued by a Kentucky bank, unless your bank had an agreement with the New York bank.
Yes. Mhm.
In which case they would let your little piece of paper get rolled out, but it was sort of every state for itself, I think.
In a sense, yeah, in a sense, and they wanted that. The state legislatures wanted that prerogative to control their own, the monetary system in their own. And so even outside of the financial system and the economic issues, there was this notion of encroaching sovereignty of this federal bank. That's actually one of the purposes is to establish a regularized national monetary system. That's what Hamilton wanted. Because the one thing the states could not do under the Constitution, the states cannot coin money. The states cannot actually, the banks in the states can issue bank notes at this time, but they cannot actually coin money. There's no such thing as like the Mint of Tennessee or the Mint of Kentucky. That's unconstitutional. That's explicitly, I think, in Article 1, Section 10. That's something that you just can't, states cannot do positively. Okay, so what does James McCulloch do? So he's obviously, he's not going to buy, he's just saying, I'm not buying your paper, Maryland. So they take him to court. And what does he do? What's his argument? Does he think Maryland has the power to even issue this tax on the bank? That's effectively what it is.
He says no.
No.
He says state can't tax the federal.
States can't tax the federal government. He says, the Second Bank of the United States is a creation of Congress. Article 6 of the Constitution says that the federal law is supreme over state law. Therefore, Maryland cannot obstruct the operations of an entity created by federal law. What's Maryland's response? How do they say? They say,
They didn't have the power to put the bank in.
yeah. So they said, all right, Jimmy McCulloch, sure we can. First of all, let's back up here. Now, I don't know if I spelled this out explicitly in that summary. But the first thing is, first of all, when the state of Maryland entered into the Union, she did not forfeit her sovereignty. Therefore, she did not forfeit her power to impose taxes on the persons and entities within her domain. Federal law is not supreme where Maryland doesn't want it to be. What does this sound like? Remember our 3 theories of federalism? Which one is this? What does this sound like?
The agreement of the states.
What's it? Compact federalism. This is compact. So Maryland is taking a position of compact federalism. They're saying, hey, yeah, the Constitution is different than the Articles of Confederation, but the same notion of the relationship to the states, to the federal government is the same. That's Maryland's operating assumption here. Second, Maryland's saying, even if we assume the supremacy of the federal law over a state's power to tax, Article 6 states that acts of Congress are only supreme over state law when those acts are made pursuant to Congress's powers under the Constitution. He says, the attorney for Maryland, the attorney general for Maryland is Luther Martin at this time. And I think I'll mention him later. He says, the Constitution nowhere says anything about banks. Congress has no power to do it. Now, this is the same argument that who had made 20 years earlier? Thomas Jefferson. Okay, so this is this was an enduring constitutional and policy dispute that had went from the very foundation of the republic, even 20 some odd years later. People are still. This is because people see this as this. We're either going to be like this or we're going to be like this, and the touchstone is this bank. And so there were people who saw this as the battle between good and evil, and. This is why the oral arguments for this case. So today, if you go to the Supreme Court, you get an hour, right? And sometimes you have to reserve some of that time for rebuttal. You get an hour. Oral argument lasted 9 full days. The Supreme Court let each side have 3 attorneys. 9 full days of oral argument, because every day the whole gallery was packed full of people, because this was a big flipping deal, this case. So Maryland is saying, first of all, the states are sovereign. Sovereignty ultimately resides with the states. And so, yeah, we have power to tax the federal bank because we're the source of federal power, we the states. Second, even if we're not, we are, but even if we're not, federal law is only supreme over state law when it's made pursuant to Congress's enumerated powers. There's no enumerated power for a bank, and the necessary and proper clause does not facilitate the bank because, hey, the bank's not necessary. There's all these state banks. If Congress wants banks to hold their money to do their transaction, there's 250 some odd state banks they can use. They do not need a federal government. Therefore, a federal bank. Therefore, it's not necessary. It's not necessary and proper because it's not essential. We fought and won 2 wars with the British without a bank. How can you say it's necessary? So these are the arguments that the Supreme Court is hearing. So how does the Supreme Court come down on this? Who do they agree with? Who does John Marshall, writing for the court, agree with? McCulloch. He comes down, so if he's arguing for McCulloch, then the bank is or is not constitutional. Is or is not? Which one? Is. It is constitutional. So Marshall more or less goes through 4 points. The first thing he does is he says the bank is constitutional. It's just a matter of historical practice. He said this is our second go around with a federal bank, fellas. The first one had been chartered back in 1791 and lasted for 20 years. And yeah, he knows that there had been quite a bit of controversy over that. But you have to understand, the men who were in Congress, who enacted the first bank, many of them were there in Philadelphia in 1787 when the Constitution was created. Do you think that they would have drafted and created this institution that was inconsistent with the Constitution that they wrote the damn thing? Okay? Second, the very first Congress passed this bill, and the first bank in the United States, and it was signed into law by George freaking Washington. Do you think he would have signed anything that was unconstitutional? Now, one may point out that this is what you may call a generic fallacy, but it carried considerable weight as an argument. It's saying, hey, George Washington thought he heard all these arguments, so you're saying George Washington was wrong. Puts Maryland and the other people of Maryland's persuasion in a tough place. But it wasn't very persuasive to Luther Martin, who was the head attorney for Maryland, because he was 71 years old at the time. He himself had been a delegate to the Constitutional Convention in 1787. And he had been there, and he was vocal opponent to the bank, to federal power. He thought the Constitution gave way too much power to the federal government when he was there in Philadelphia. He had been a vocal opponent of the bank, the first bank, and he was here 28 years later opposing the second bank for the same exact reasons. So that was Marshall's first point is, hey, it wasn't unconstitutional before. It's not unconstitutional now. Not a good argument if you ask me. We can say that about a lot of things. Hey, we've always done this. Okay, but that's not his only argument. The second thing Marshall does is Marshall really kind of cuts to the heart of really what's going on here. It's kind of lingering in the background, but he addresses it head on. And what's the underlying dispute is federalism. This notion of compact federalism. Marshall wants to dig this up and get rid of it. He smells a rat and he's out to kill it. He says, in discussing this question, the Council for the State of Maryland have deemed it of some importance in the construction of the Constitution to consider that instrument not as emanating from the people, but as the act of sovereign and independent states. The powers of the general government, it has been said, are delegated by the states, who are alone truly sovereign, and must be exercised in subordination to the states, who alone possess supreme dominion. Now, I think that's a very fair representation of the more Jeffersonian compact theory of federalism under the Constitution. But he's saying this is what they're saying. And he goes on to say, wrong. Not the case. That notion of federalism, let's just dispense with that right now. That's not the case. He says, the federal government proceeds directly from the people, not from the states. The Constitution doesn't say we the states. It says we the people, in order to form more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, for the blessings of wealth. I forget after that. Okay, it says we the people, not we the states. Proceeds directly from the people, in the name of the people, and is declared to be ordained in order to form more perfect union and secure their blessings of liberty. Now listen to these next few lines and tell me if you think this is a prototype of something that will be said later on in American history. The government of the Union, then, whatever may be the influence of this fact on the case, is emphatically and truly a government of the people, in form and in substance. It emanates from them. Its powers are granted by them and are to be exercised directly on them for their benefit. Government of the people, by the people, for the people. This was the initial rhetorical framework that Daniel Webster went on to use in his debates on the Senate floor with the Southerners in Congress when he was speaking out against the compact theory. And then this is about 30 some odd years later, the words government of the people, by the people, and for the people, words that one of Marshall's greatest admirers, Abraham Lincoln, would say when he was at war with the compact theory in arms. That's exactly what the Civil War was, in a sense. So this issue was very personal to Marshall. So think about it. Jefferson and Madison and Randolph and Patrick Henry, all of these people who were the anti-federalists and the staunch Republicans, guess what none of them did? None of them fought in the American Revolution. They all played an important role, absolutely. But none of them were actually in the army. Marshall, on the other hand, while they were arguing politics in the state houses or in the Second Continental Congress, Marshall was fighting alongside of Alexander Hamilton because he and Hamilton were both officers in Washington's staff. And so Marshall had been there at Valley Forge and had endured that suffering cold winter at Valley Forge with Hamilton and with Washington, with all these men from all over the country, from all over the different colonies that would become states. And Marshall had learned from this experience. He had seen how firsthand how useless and weak and futile a powerless central government was. He had seen this army that he was in nearly starve to death because of a Congress that could not do anything to fund it. And he had lived under the Articles of Confederation, and he had seen the kind of havoc and obstruction that resulted when you left the states in charge of running their own affairs. And so while many of Marshall's contemporaries would often refer to, say, their home state, for instance, Thomas Jefferson, when he was away going to New York, he would say, "I'm so sad that I'm so far away from my country," namely Virginia. Virginia was his country. Samuel Adams would say Massachusetts was his country. That's their sense of national identity. But Marshall's experience in the Revolution made him a true blue American nationalist. Now, this is something Marshall said later in his life. He said, "I had grown up at a time when love of the Union and resistance to Great Britain were the inseparable inmates of the same bosom. When the maxim, united we stand, divided we fall, was the maxim of every Orthodox American. And I had imbibed these sentiments so thoroughly that they constituted a part of my being. I carried them with me into the army, where I found myself associated with brave men from different states who were risking life and everything, valuable in a common cause, believed by all to be most precious, where I was confirmed in the habit of considering America as my country and Congress as my government. So this is Marshall saying, this is why Marshall has such an axe to grind with the compact theory. He had seen what the compact theory leads to. He didn't want that. So that's why he goes after that immediately. Now, the third point he makes is actually the most important point for our purposes of this class. It's the point about the necessary and proper clause. And so Marshall says, you know what, Luther Martin, state of Maryland, all you Republican people who want the compact theory, you're right. There is no mention of banks in the Constitution at all. But you misunderstand the necessary and proper clause. Necessary, the word necessary, does not mean absolutely essential. It does not mean indispensable. Rather, necessary here means useful or conducive to. Now he's ripping off, he's stealing this language from Alexander Hamilton, who had described the meaning of this word in the Federalist Papers. And he's adopting a more broad, liberal, robust reading of the necessary and proper clause. And so he says, we admit, as all must admit, that the powers of the government are limited and that its limits are not to be transcended. He's saying, yes, I agree with you, that Congress has limited powers. It's not like the states. It does not have a general grant of authority to do whatever it wants. But, we think the sound construction of the Constitution must allow to the national legislature that discretion with respect to the means by which the powers it confers are to be carried into execution, which will enable that body to perform the high duties assigned to it in the manner most beneficial to the people. Now, this is the most important line. This is his description of how we should understand the necessary and proper clause. Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and the spirit of the constitutional, and they are constitutional. So he says, if it's an appropriate means to the end of pursuing these enumerated powers, then it jives with the elastic clause. It jives with the necessary and proper clause. This is a much, much more expansive reading than the Jeffersonian Republicans wanted and that the state of Maryland wanted. And it was definitely a very different take on federalism than they had wanted. Any questions so far? If not, how about a break right now? Sound good? Okay. In case I forget at the end of class, I have new handouts that everyone should grab on your way out. There's 2 handouts here. And I don't think we're going to be discussing these next week. We might get into them, but there's 2 different handouts.
I can't pretend to follow you really, but anything that you discussed that would pertain to the Second Amendment,
Okay.
I wish you kind of bumped that into your discussion.
Well, the Second Amendment does not actually pertain to any actual powers of Congress. But what's interesting about the Second Amendment is that if you look at the rest of the Bill of Rights, all of them, for instance, like the First Amendment, says Congress shall not make any law doing X, Y, and Z. All of the First Amendment seem to specifically limit Congress's authority. The Second Amendment is different. The Second Amendment says a well-regulated militia being necessary to the safety of a free republic or something to that effect the right of the people to keep and bear arms shall not be infringed. It doesn't say the states can't do it or Congress can't do it. It says it just shall not be infringed. Now, I would say the ideology behind the Second Amendment is more akin to what Jefferson and Madison, the more classical Republican understanding of republicanism, because it was bent on everybody in the body politic having civic agency, having power to govern their own affairs and be involved in the community. And so what they didn't want, what the Republicans did not want, is for there to be a professional military and then other people be disenfranchised from having the power to guard their own communities.
But there is no way they could have seen, and I don't think there's any way it applies to wholesale slaughter we have today. Well, the Constitution guarantees.
Well, sure.
Makes no sense.
But think of it this way. Being devil's advocate here, think of it this way. If the purpose of the Second Amendment was to confer civic agency on citizens to be able to participate in the defense of their own communities.
I don't think any of these guys would be accepted into the militia.
No. So think about the preamble to the Second Amendment, or like to the pretext of the Second Amendment is a well-regulated militia being necessary. So it had to do with people having the agency, having the ability to participate in the defense of their own communities. I mean, what you hear a lot of times from people is the Second Amendment was about power to the people having the power to overthrow the government. I don't think that's necessarily true. I think it's about the power of the people to be the government. Does that make sense?
Yep.
Yeah.
I
It
think
was
that's
we
it.
are the state.
And now, apparently, the Supreme Court for the first time forgot about the first sentence.
I'm talking about that D.C. versus Heller case.
Yeah.
Yeah. Well, because I think we had this modern scheme of incorporated fundamental rights through the 14th Amendment that wasn't there. Obviously, wasn't there until 1868. So it wasn't there when it was framed in 1789. And so now we have to look at it as the courts have to take it and say, does this particular right, does it apply through the states? Of course, D.C. versus Heller was federal, but there was another, the Chicago case. I'm trying to think what it was called. But the question is, the question in those cases is, does the Second Amendment protect an individual right, or is it a collective right? But here's the thing: if it's a collective right, what does that right look like in today's context? What does it look like to have them? Because we don't have there are state militias, I guess, but we don't.
Virginia has a militia.
Yeah.
But
Something in his third point that you just read, the good of the people,
I
the
would
good
say-
of the nation. Go ahead.
for the military, you need to pass tests, have examinations, and have training to be able to be accepted. And I would think for the militia, that might be also possible.
Well, you're absolutely right, because we talked about the Judiciary Act last time. That was in 1789. In 1790 or 1791, Congress passed the Militia Act. And what the Militia Act did was actually regulate, hey, all men between 22 and 44 or something like that, you all have to have guns. And not only you have to have guns, you have to have knapsack, you have to have so much shot on hand, so much powder on hand, so many flints on hand, because we need everyone, because at this time we have British on the western borders, still forts out there, there are Indians, it's like everybody has to have guns.
Yeah.
That was the militia, the Militia Act.
Yeah, that's all that's history we don't know very
Yeah.
much. Can I bring up, just in passing, not for a real commentation, about the internet, that the Congress has the power to regulate the post roads, which is very similar to the internet.
Yeah.
And now we're going to go back into medical care, that Congress has the power to do what's necessary for the general welfare as a specific.
Well, they have power to tax and spend for the general welfare. They don't have power to regulate for the
Oh,
general
well,
welfare.
that's what somebody I
We're
said.
going to talk about the ACA
Okay.
case
Yeah.
later on in the course.
All right.
Yeah.
Thank you.
So save those thoughts definitely, because that's going to be very important to our discussion later. Okay, everybody ready? Okay, so we've been through 3 of Marshall's points here. First of all, hey, 1, we had a bank before. It was constitutional then when George Washington signed it. It's constitutional now. Second, the compact theory of the compact theory of federalism is garbage. Don't bring it up again. Third is that Congress does have authority to enact the bank under the necessary and proper clause. It is necessary and proper. It's a useful and conducive means to the end of a plethora of different. I mean, like I said earlier, the Navy, Post Office, all of. I mean, they relate. It relates to nearly all of Congress's enumerated power. So it is necessary and proper to the ends. I mean, you can think about it in like Machiavellian terms. The ends justify the means, in a sense. The last point that Marshall brings up is that Maryland may still not be sold on this. There's still an argument that Maryland has up its sleeve. Even if we dispense with the compact theory, and even if Congress did have the power to charter this bank, let's say we grant that, still, why can't Maryland have this tax? It's not like Maryland is nullifying a federal law here. Yeah, there's the supremacy clause, and federal law is supreme over state law, but Maryland's not nullifying anything. How is just saying, hey, if you're going to be a bank in the state of Maryland, print your bills on this money? How is that a violation of the supremacy clause? Any ideas?
He says because, quote unquote, the power to tax is the power to destroy.
The power to tax is the power to destroy. The power to destroy may defeat and render useless the power to create. There is a plain repugnance in conferring on one government a power to control the constitutional measures of another. If Maryland has the ability to tax a federal entity, they have that is implicitly the ability to destroy a federal entity. Taxation implies sovereignty. Governments tax subjects. So if Maryland lays a tax on a federal entity, however slight that tax is, that the very existence of that tax is repugnant to the very principle of federal supremacy. Because what it communicates is the federal entity is a subject of the state of Maryland. Do you see what I'm saying? That's what John Marshall's saying. So Marshall's logic is if the state has the power to tax institutions created by the federal government, it has the power to obstruct those institutions. Even though it's not express nullification, it's de facto nullification. It undermines and it's repugnant to the supremacy of federal law. Think of it like this. If Maryland taxes a federal entity like the Second Bank of the United States, it's taxing an institution that's created by the federal government, which is a government of the American people in aggregate. Maryland is effectually taxing something that the people who live in other states, through their representatives in Congress, created. Maryland is effectually taxing people who are not Marylanders. It's taxation without representation. Isn't that what the revolution was about? So that totally dispenses with, no, I don't care how slight this tax is, even assuming the compact theory is gone, and assuming that Congress has the power to do this, Maryland still cannot tax the federal bank. All right. Any questions about that case?
How did John Marshall, did he have, I mean, he is really thinking outside the box.
Mhm.
The two decisions we've looked at have
Mhm.
been landmarks.
Yeah, we're going to read one more of his next week.
Okay.
Mhm.
Was there British law? Was there anything? How? He just thought all this up?
Well, okay. There are two books I think I have listed in the supplemental reading in your syllabus. One of Mr. Barber, I believe he's not here this week. He sits over there. He and I discussed the book he and I both read recently by Richard Brookhiser. I believe he's like an editor with the National Review. He recently had, in the last few years, come out with a very good biography on Chief Justice Marshall. And then there's a longer book that I think is quite a bit more heady, that's written by a law professor somewhere in California. His name is Joel Richard Paul, or Joel, I think that's his name. He's wrote a pretty long biography of John Marshall. I think I would refer you to those books that would give you a much better account of Marshall's intellectual background than I could. I will say, the issue, his experience definitely guided his view of federalism, that's for sure. His view of the relationship between, he had seen what happens if you let the states have their own way, and he didn't want no more of it. He had the same notions of Alexander Hamilton. And so even after the War of 1812, after the War of 1812, federalism virtually died out. I mean, when I say about the Federalist Party virtually died out. There's different senses in which we can use the word federalism. The Federalist Party as a political bloc virtually died out. But yet Marshall's still on the court until the 1830s. So he is an enduring vestige after the Jeffersonian Revolution of 1800 and the even more kind of radical Jacksonian Revolution in the 1830s, with this promulgation of something that's more akin to the compact theory or a very loose dual sovereignty theory of federalism. That is still going on the popular level, yet John Marshall is still Chief Justice of the Supreme Court. And so he has this enduring legacy of checking all of these democratic excesses that are going on in this democratic zeitgeist of the first half of the 19th century, so to speak. He's definitely an interesting person. I could say more about his education and things like that. I will say when he was like 12 years old, his father, I think if I can recall, bought him one of the very rare first edition copies of, we mentioned last time, Blackstone's Commentaries on the Laws of England. And he read that and committed a lot of it to memory. And that's what you read when you were a lawyer, though.
My second question is, how angry did people get when he did something like this?
Oh, it was terrible. Actually, immediately after this decision came down, there was a lot of outrage. People like Spencer Roane, who was the Supreme Court, the Chief Justice of the Supreme Court of the state of Virginia, he and some other of the kind of really mad dog Republican ideologues took to really just lambasting this decision in the papers. And how Marshall reacted is something that we would not expect from a sitting Supreme Court justice. He wrote back. He submitted his own opinion pieces in newspapers. So there is this ongoing colloquy, this argument in the newspapers between Marshall writing as the Supreme Court justice in the papers, and these other like Spencer Roane and Edmund Randolph and these other Republicans. We wouldn't if say John Roberts today wrote something in the newspaper. I mean, I don't think he even tweets anything. I mean, it's because he wants to preserve the independence, the impartiality of the court. Yes, sir.
Did this change then how states tax banks like Kentucky?
Well, I'll say this. I don't know about Kentucky. At this time, Kentucky was a very hectic place. There was actually an exodus out of Kentucky because the economic and political atmosphere in Kentucky was so bad, people didn't want to buy land here. So I don't know. It was a mess in Kentucky. I'll tell you what happened in Ohio. In Ohio, right after this decision came down, the state of Ohio actually, how'd this happen? Let me see if I didn't come prepared to remark on this. Something to the effect of the state of Ohio wanted to collect this $50,000 tax that they had imposed. When $50,000 was a big sum of money in 1819. This $50,000 tax on the federal bank, and so I think it was like the Chillicothe branch of the bank in Ohio, and they had just sent like armed ruffians to like jump the counter. They call it the crowbar law, because in Ohio, because it gave like these licensed state ruffians, these ne'er-do-wells, the ability to just like, hey, here's some money, and we want you to go down to the Chillicothe branch of the federal bank and just bust the windows out, jump over the counter, thump the skulls of the cashiers, and steal all the money they have in here. Literally, that's what happened. That case also went to the Supreme Court, and I'm trying to think of the name of that case. I'm blanking right now. Something to look into. But yeah, so there was, the states didn't just immediately comply, but yeah, more or less the taxation of the bank stopped. But, as an epilogue to this, like I said, people absolutely loathed the bank as an institution. They hated it. And so in the aftermath of this decision, it contributed to a major political realignment in the creation of a new political party system. So, like I said, after the War of 1812, the Federalist Party had just virtually become extinct. And there was this short-lived kind of Republican consensus. People often call it the era of good feelings. But this kind of zeitgeist changed, and the Republicans found themselves divided into more or less two camps. The National Republicans, and I mentioned earlier, who were they weren't Federalists by any means, but they saw the federal government more as an instrument of fostering national unity and commerce. So these are people like Henry Clay and Daniel Webster. They wanted internal improvements, national roads, projects, things like that. What you may call Henry Clay's American system. Anyone heard of that? Familiar with that? And then there were the Democratic Republicans, or simply the Democrats. And this is actually still this is the birth of the modern Democratic Party, still the same. It's the oldest political party in the world. And the Democrats were paranoid and very circumspect about any concentration of power in the federal government, especially the bank, especially central banking and central financial system, anything that was built upon the federal government. And so this decision, over the next decade, the bank did continue to grow, and its influence over the economy grew, and people just absolutely resented it. And so this oversized influence of the bank, in conjunction with this decision, caused a popular backlash against the bank that would lead to the ascendancy of the Democratic Party and the instances of more states actually deliberately nullifying state law. So you can think of like what South Carolina did just a few years later with respect to the tariff. They just said, we're not doing it. We got more backbone than Maryland does. We're not complying with this law. And it also led to the election of Andrew Jackson. Andrew Jackson, he was the man who would have ultimately dismantled the whole bank when its charter expired. And he, unlike Jefferson, was somebody who was willing to just face John Marshall head on and actually ignore and defy one of his decisions. And I think it was Worcester versus Georgia. It pertained to Indian removal. And so Andrew Jackson famously said, Mr. Marshall has made his decision. Now let him enforce it. So this decision helped can contribute to this popular fear of federal power, and kind of led to this popular backlash. Another thing is the reason it kind of worked so people up is it left people kind of uncertain as to what the limits of federal power were. Because now the government that most people thought they had in the federal government was kind of a much bigger monster. They had a much bigger tiger by the tail than they thought they had. And so there was this rush to check federal power, so to speak. Because they didn't understand, they didn't think that the courts would read the elastic clause to be that elastic. Does that kind of make sense? Or am I just rambling? Any questions? Am I not being clear about anything? I see some confused looks. I'm sorry.
It's a lot to think about.
Okay. Let's talk about some questions really quick. Okay, so Congress can enact any law as a means to an end of pursuing its enumerated powers. But just how attenuated can the relationship between the means and the end be? That's the issue when it comes to the elastic clause, or the necessary and proper clause. So let's talk about some examples. This gentleman, is it Robert? Is that your name, sir?
Yes.
You brought up to me the postal system. So Congress has, in Article 1, let's look at this. I think it's, let's see, which one is it? To establish post offices and post roads. Article 1, Section 8, I think it's 1, 2, 3, 4, 5, 6, 7 clauses down. Congress shall have power to establish post offices and post roads. So Congress wants to create post offices, they can just directly do it. The necessary and proper clause is not implicated because it's direct power that's enumerated. But what if Congress wants to create a law, pass a law that creates zip codes? Is that okay with the necessary and proper clause? That seems, it's necessary and proper. We want to have post offices. We have to have areas that are defined that those post offices serve. That's okay, right? Everyone agree? Okay. What about laws regulating how and when the mail is delivered? There was a time before the 1830s that mail was delivered on Sunday, and then eventually it stopped being delivered on Sunday. And that's a very interesting story if you want to read about that. Can Congress pass a law saying we want mail delivered every day on 6 days a week? Can they?
I would think so.
I mean, that seems, it's reasonably related. It's, rational, you see what I'm saying? What about law regulating the specifications of post office vehicles? Can Congress say, you know what, we prefer that mail not be delivered on Harley Davidsons. Maybe we think Jeeps are a better idea. Can Congress do that?
Yes.
Why not?
Control the money.
Yeah, it's necessary and proper to creating the post offices and the roads. Okay. What about a law mandating that all mail be sent in envelopes that are made of water-resistant paper? No? Why not? I mean, if we're going to create a post office, we're going to create post offices, and we have, we leave our mail out in mailboxes now. We want people to get information through the mail system. We can't have their mail be getting all soggy. So we can say, hey, in order for us, it's a necessary and proper means of fulfilling this power. We're going to mandate that all envelopes have to be water resistant. Can they do that? Congress do that?
Well, I think they could argue about it. They
Yeah.
have ways to create mail that they provide, they have water resistant envelopes. They have boxes that are sealed,
Mhm.
they have all these things. Yes, I think they could.
You think they could?
Whether you could have to use them only is, I don't know, if they have to make you take mail that is soggy. I mean, it's up to you if you want soggy mail.
So, I mean, this is where it begins to say, here's the means and here's the end. Yes?
Well, they regulate the size of an acceptable envelope.
Yeah.
So I'm thinking, yes, they could regulate the type of paper.
Yeah. Yeah, I mean, they probably don't want
They
like,
have to be the only ones that sell.
what's that?
They don't have to be the only ones that sell.
No, but can they say, if you want to deliver mail through our post offices that we, Congress, create, it has to meet these specifications. Can they regulate mailboxes?
Yes.
They do
Yeah,
regulate.
they do.
Yeah, they do, but can they? There's all kind. That's what this class is about. Congress does X, but can they do X? Can Congress say, hey, if you want to get mail from us, you can't just put out a shoebox at the end of your driveway? I mean, the consensus is yeah. I mean,
Yes, because
right,
of
but.
the height and everything with the cars.
But think about this with me. How attenuated, how far removed, how remote can the means be from the end? Could Congress regulate? Could they pass a law regulating vicious dogs? I mean, think mail carriers. If they're going to deliver mail, they don't want to have to. They're not going to be able to do their job well if every other house has a pit bull or some other kind of mean dog. Not all pit bulls are mean. I'm gonna hurt somebody's feelings. Somebody's got a lovely, beautiful pit bull at home that is just really, really nice, and I've just hurt their feelings, and I apologize. There are pit bulls that are very nice, but a mean dog.
I would say no, because that's now getting into personal property.
But isn't paper personal property? If I buy the paper,
Not
can I?
necessarily, because the reason why they have certain sizes is because of their machinery. And that has to do
Yeah.
with money and efficiency and everything.
I would say that getting bitten by dogs is pretty inefficient.
But that's so subjective.
Well,
Okay. I'm gonna argue. By the way, I'm gonna argue with everybody.
I think that would.
Okay,
Yeah.
go ahead.
I guess you have to look at established and high, and
Ah.
that gets to be very,
Yeah, because it doesn't say Congress shall have power to deliver the mail. It's implied that they have, that means deliver the mail. I mean, what else are you going to establish a post office for?
well, I mean,
Right?
established would include detective vehicle, it include
Yeah.
everything that is representative of the operation, the actual
Mhm.
process of picking up the mail and delivering it.
Yeah.
When we come down to states' right outside.
Ah, ooh, you're right on it. You're right on it. You're right on it.
Dogs are usually controlled by local.
Because what do states have? Yeah, there's dog catchers, animal control. Can the states? I mean, that's what the states do. Because states have what? They're not like the federal government. They don't have limited powers. They have what? General police power. States can do anything that's not proscribed. Congress can do nothing unless it's prescribed. Does that make sense? But could Congress create, let's say, like a federal system of salt trucks and snow plows? Because hey, especially maybe Minnesota, Michigan, North Dakota, roads get all snowy there. We still want people to be able to get their mail, and maybe the states aren't going to do it. So we're going to create in every county there's going to be a federal road department. And then the road departments are going to go out and salt the roads and plow and everything, not just on the interstates, but on all the state roads.
Because the states have public works departments.
Well, yeah.
But if the states do it, but does that mean that Congress can't?
Only on federal roads, though.
On the roads they.
On the interstates, yeah.
Yeah.
But what about on state roads? Because people, I mean, I don't see very many mailboxes when I go down I-65.
Yeah.
But,
They may provide money to the states to do that.
ooh, we're going to talk about that later too. Because you're talking about their taxing and spending power.
Yeah.
That's a lot broader. We're going to get there. I know I'm cutting off a lot of people saying, oh, you're saying something we're going to get to. I don't mean to cut people off.
Territories, they probably have the power.
Ah, yeah.
Direct governing power.
Yes, in territories, Congress functionally does have police powers in federal territory. For instance, like, before Alaska became a state in 1948 or 49, Congress was the general police power over.
Puerto Rico?
Yeah, I guess.
Virgin
Yeah, that's a good question too. I was actually a park ranger man with K for 2.5 years, so I've got that one's near and dear to my heart. Okay, what about?
Is that Columbia?
Yeah, in the capital certainly.
Because they're not a state.
They're not a state, yeah, but it's exclusive federal domain. What about a law criminalizing mail theft? Typically, criminal law is something left to the states, but can there be a federal crime of mail theft?
Yes.
I thought it
Yeah.
was
Yes.
There is one. But can there be? There is one, but is it right? Is it constitutional?
Nobody else was doing it, so.
Well, the states could do it, but
Yeah,
yeah.
but if it crosses several state lines, it's more
Ooh,
efficient for the.
yeah. Okay, here's another one. Congress has, get through this quickly. Congress has another enumerated power to coin money. So can Congress pass laws regulating what kinds of metals the coins are made of? They can say, we would prefer, okay, they can do that. Okay, everybody agrees.
Law, does it have to be a law though?
Well, I mean, it would be an act of Congress saying, or, and not just an act of Congress, it would be a grant. And this gets into administrative law. That's probably above my head, and what I do know is not something I'm willing to get into now. But a delegation of legislative power to certain agencies to govern, to make regulations, administrative regulations. Okay, but still, that would go back to power to do that. What about laws regulating the price of certain metals? So if we're going to make coins out of, copper, can Congress pass a law and say, hey, we think copper should be this price and no higher because we got to buy it and make coins out of this stuff? Can they do that?
No.
Why not?
They regulated the price of gold for a long time and then you
Yeah.
figured it out.
Is that a means to an end, or is that too remote? How are we going to describe this?
When gold was, I guess, was the species.
Yeah.
They could regulate the price. And then some people came along and wanted to make silver equal the gold,
Mhm.
and they argued about that for quite a while.
What about laws chartering companies to run like copper mines and smelting furnaces and paper mills to supply the federal mints? If Congress says, hey, we have to run these mints, but we think the private market is too expensive to buy our metals from and to buy our paper from, so we're just going to charter a company to say run a copper mine, and then we're basically going to set up a copper company, may have our own production. Can Congress do that? But it says to coin money. Isn't that part of the coining process? You need metals, and if we have paper money now, we need paper.
You know, I think they
only
would
buy one
argue
paper.
about it.
Huh?
They only buy one paper for paper money. And
Could Congress say we're gonna this federal land over here, we're gonna plant that with trees, and we're gonna use that to have our own U.S. paper company?
If there was a need to do that, for example, if all of a sudden there were no trees and no other paper, they could say, gee, we need paper, we're gonna have to make these decisions. I think those would really depend upon the circumstances.
Okay. What about a law criminalizing counterfeit money?
Yes.
Sure. Yeah, I mean, here's the thing. It exists. We all know it exists, but is it constitutional, and why? Is that law a proper means, is a necessary and proper means to the end of Congress's power to coin money? Yeah, because Congress has that power. Billy Bob in his basement doesn't have that power.
You could debase the value of the
Exactly. So what about if Congress passed a law that required like all gas stations to have cash registers that could detect counterfeit bills? Could they do that?
Now I think you're going to the state.
Is that a state thing? I mean, the states don't coin money. What motive do the states have in making a law like that?
because the federal government will not honor counterfeit money. So there would be a law.
Sure, but what I'm saying, well, okay, I see what you're saying, but
But there are
They
several
don't pay
means
for it,
of
so-
identifying
Mhm.
counterfeit money.
But, okay, I'm not aware of any state law. Kentucky, I don't think, has any state law that requires stores to have a counterfeit. I mean, like, you see people mark it and look at it. But could Congress pass a law saying, hey, if you're going to have a gas station, or if you're going to have a Walmart, a store that's like fits a certain description, your cash registers have to have a certain machine that we have approved as Congress that will detect counterfeit bills. Even like mom and pop's convenience store on the corner of Good Old Boy Road. Like,
Because it's unnecessary.
but isn't that the definition of necessary that Maryland had in this case?
Yeah.
Like I said, I'm going to argue with everybody because I want us to get that. Because I want to show you this
Well,
language.
There are other methods
But
to detect these.
but does Congress have to pick?
And
Does-
I would say that if it came down to that there was so much counterfeit money in circulation,
Mhm.
that it would threaten our economy,
Mhm.
then it shows that the government has lost control.
Yeah.
And
Well,
maybe,
that's not what you can, you manipulate machines.
yeah, there'd be some way, but they'd be figuring out how to put in charge.
Yeah. Real quick, because we only have 5 minutes, I want to get through. I just want to talk about this case. Did anybody read the summary I gave you for United States versus Comstock, 2010 decision? Much more recent. What's going on? Real quick, what's going on in that case in Comstock?
Man charged with mental illness,
Uh-huh.
charged with pornography,
Mhm.
in jail. He is found to be mentally ill. He's serves his term,
Mhm.
and instead of releasing him to the community, the government releases him to an institution,
Mhm.
committing him as mentally ill.
Okay. So this act, I think it's called the Adam Walsh Child Protection Act or whatever, what it did was if you're a federal inmate and you have violated a federal crime, you've been sentenced by a federal judge, found guilty by a federal, you didn't go down here to the state, to the Warren County Justice Center, you were in the federal courthouse, and you're a federal criminal. If you're a federal criminal and the Department of Justice, the Department of Bureau of Prisons and Corrections or whatever it's called, I'm not familiar. And they adjudge you to be 1, mentally ill, and 2, sexually dangerous, then after your sentence is served, if they still determine that you meet those 2 factors, then the Department of Corrections has the prerogative to send you to a civil commitment. Okay? Now, which enumerated power is this a necessary and proper means to fulfilling? Everybody see that kind of diagram I have drawn in your
Yes.
thing? Okay, so these are, for instance, here's coin money, here's post office, here's commerce, here's like a crime, here's counterfeit, here's a counterfeit statute, criminalizing counterfeit. Here's criminalizing mail theft. Here's criminalizing selling drugs, okay? And here's federal prison. I don't know if this is exactly what I drew. Okay, here's ability to, and over here is this civil commitment statute.
Isn't there a current case going on with someone
There might be. What's interesting about this case is that this statute was challenged on a whole bunch of different grounds. This is a very narrow view of one issue, namely the necessary and proper clause issue, because there were lots of other, for instance, think about due process. You're extending, you're functionally, the government is essentially extending somebody's prison term without going through a jury, without going through due process of law, arguably. I can't remember how that was settled, but
The whole problem of commitment, I think, is very difficult and it's not done very well at all. And there are so many examples of mismanaged commitment that it's really pathetic. But I
Yeah.
don't think anybody has thought it through to figure it out yet, how to do it.
yeah. So here's where we were at with this civil commitment statute, which, and here's our Article 1, Section 8 list of enumerated powers. So which one is it a necessary and proper means to? If the necessary and proper clause gets us here, okay, think of this as these links as a necessary and proper clause. The necessary and proper clause is like an like a long arm, like an extension. Here's enumerated powers. It's like a tool, like a wrench, but the enumerated powers can't reach to this certain thing that Congress really needs to do. So think of the necessary proper clause in a sense maybe that it's like an extension on this. It's like, hey, I can reach this because it has this source of this enumerated powers. And I don't know, maybe it's a bad illustration. My hand gestures are probably not helping. But think of this as these links. So which enumerated power does it connect to?
The last one, power to civilly commit inmates deemed dangerous.
That's not enumerated power in the Constitution. No, that's the power that's what the statute does. But which power? I mean, the answer is none of them. It doesn't relate to any of them directly. Look how remote this is. So the question this raises is the necessary and proper clause now a power within itself? Does Congress even have to point to an enumerated power? Or can they just say, this is something that in the circumstances of how we run the government, now we have to do this? It's expedient to our just running the government how we've ran it in the last 50 years. It's a very different animal, even maybe than Marshall even thought. Because the dissent here, I think Justice Scalia and Thomas, I believe, were in the dissent. They said, hey, you can't point to any enumerated power. The necessary and proper clause is only a link from an action to an enumerated power. You can't do that. It's so ambiguously attenuated from what Congress is doing to what Congress has the power to do. You can't even connect it. It's so incoherent. What you're saying now is that the necessary and proper clause is now functionally a power within itself, in a sense. Something to think about.
There is a need for that. I can name several cases where someone has been committed, gone before the judge, discharged, goes out and creates almost immediately terrible crime. One in Ohio, was discharged from the Army. He was narcotic. He killed somebody. He was discharged to the state hospital and transferred to the VA hospital. He was treated and improved, discharged to outpatient care because their billing was the law that once a person is no longer
Yeah.
dangerous, considered dangerous, you can't keep them in the hospital. Immediately discontinued his care, relapsed into psychosis, had a gun, went out and shot a young college student working during the summer. Boom. Dead.
And this raises a really good issue. I'm glad you said that, because what we're going to talk about in the next few weeks, especially with the Commerce Clause that we're going to start discussing next week, is there are certain things which we really think, as you know, just as a matter of common sense, that just ought to be done. There ought to be a law, right? But does Congress have the power to do everything that ought to be done? There are certain things where we're going to talk about certain cases, involving the Civil Rights Act, involving violence against women, where people who hate racism and hate violence against women have nonetheless said, Congress does not have authority to regulate this. I'm sorry. Yes, it's bad. We hate it. But what we hate more is a government that's going beyond its powers. Does Congress, just because Congress ought to do something, does that mean it has the power to do it? Because governments don't always do just what ought to be done. And who defines ought? This is the kind of issues that we're going to talk about.
I think it's a shame that judges can't make mistakes, because in both these cases that I'm familiar with, these were orders from the judge. These things had to be done. The person had to be in the least restrictive environment possible that perceives the situation. However, there's not any way to judge that.
Yeah. Profound questions. Any other questions before we leave? All right. Please don't forget to get one of a copy of each of these two handouts. Next time we're going to discuss our last Justice Marshall case, which is Gibbons versus Ogden, and we're going to start talking about the Commerce Clause.